Hi, this is Nick Critelli in Des Moines, your Conflicts and Ethics Counsel, with today's video brief. We want to welcome Frank Hoyt and our friends at Midwest Lawyers who bring this law brief to their law firms. We hope they enjoy it. Now, in its last return, the Iowa Supreme Court decided a case of first impression, not only in Iowa, but also on an issue that has not been addressed by the U.S. Supreme Court. It's a criminal case concerning criminal sentencing. So let's go to Suzanne for today's brief.
State versus Harrington. A case of first impression involves the application of the presumption of judicial vindictiveness established by the decision of the U.S. Supreme Court in North Carolina versus Pierce. The presumption arises when, after a successful appeal, a case is sent back to the trial court for resentencing and the second sentence is greater than the first. The question before the Iowa Supreme Court is what happens when the resentence is greater on some of the counts charged, but lower in the overall aggregate. At the first sentencing, Harrington received a total of 40 years, 30 years for count 1 and 10 years for count 5. The so-called Park School enhancement, i.e. intent to deliver within 1,000 feet of a park or school, was not applied. At the resentencing, Harrington received a total of 30 years, 15 for count 1 and 15 for count 5, and the Park School enhancement was applied to each count. Harrington complained that although his overall sentence decreased because the district court applied the sentencing enhancements, which had not been applied when he was originally sentenced, he was entitled to a presumption of judicial vindictiveness under Pierce. The issue before the court was whether the presumption of judicial vindictiveness was applied by looking at the overall or aggregate amount of time imposed by the sentencing package or by an individual count-by-count analysis. Applying the aggregate rule, Harrington's resentence was 10 years shorter. However, the sentence on count 5 was increased from 10 to 15 years. If Harrington was successful in his argument, the 15-year count 5 sentence would be vacated, leaving him with only 15 years. Justice Hike, writing for the court, noted that this was a case of first impression in Iowa and that the U.S. Supreme Court had not decided the issue. Nationwide, 3 theories have been used. A majority of the federal and state courts use an overall aggregate approach. 2 federal circuits use a reminder aggregate approach and take into consideration no reverse counts after appeal. And a minority of state courts take the count-by-count approach that Harrington used. The Iowa court sided with the majority and adopted the aggregate approach. The court found that it best promoted the rationale underlying the Pierce presumption, which was to prevent vindictiveness on the part of the sentencing judge. If the overall resentence was lower, it could not be the result of judicial vindictiveness. The court concluded by noting that applying the aggregate approach should not discourage defendants from appealing their convictions. Harrington gained 10 years by appealing his convictions.
Okay, let me add a footnote. In his opinion, Justice Hecht was very explicit to draw a distinction between identical provisions in the U.S. Constitution and the Iowa Constitution. Now, this is happening a lot. Provisions in both constitutions may be identical, but the Iowa Supreme Court specifically reserves to itself the right to interpret its constitution differently. A word to the wise. When raising a constitutional issue, be sure to raise it in dual format. That is, under the federal Constitution and also the state Constitution. Until next time, this is Nick Critelli in Des Moines. Thank you for watching.